This is Runkel with the latest report on whether sexual orientation discrimination violates Title VII. Back in April, we had a case out of the Seventh Circuit which went to the entire court, and they decided 8-3 that indeed sexual orientation discrimination does violate Title VII, and that court is not noted for being particularly liberal. But now, on January 25 of 2018, we've got Lori Francina versus the City of Providence, in which the First Circuit has decided that sexual orientation discrimination violates Title VII. Now, Francina was a lesbian firefighter who was being treated horribly by her fellow firefighters, name-calling, shoving, throwing stuff at her, and so on. And she complained, of course, to management, but things only got worse. Other firefighters joined in, and eventually she retired on disability with PTSD as a result of this horrible treatment. She filed a lawsuit, went to a jury. The jury found in her favor on a hostile work environment, plus retaliation, and awarded over $800,000. Now, technically, there's a problem here because Title VII prohibits discrimination on the basis of sex, and cases historically have decided that sex really only means gender, which means male and female, and it does not include sexual orientation. So what this court did, which is similar to what the court did in the Seventh Circuit, was they used a theory called Sex Plus, which is a theory that lawyers have known about for literally decades. It's Hornbook Law, and it's where you take a case. I'll just give you an example. You've got an employer who treats women with children differently from the way it treats men with children, and differently from the way it treats women without children. So that's sex, male, female, plus children, not children. And courts have historically found that that violates Title VII, and so that's exactly what the court did in this case. You had sexual specific slurs, and you had sexual orientation specific slurs. So we take the sex plus the sexual orientation, and you have a violation of Title VII. So that's where we are in the First Circuit. Meanwhile, in the Second Circuit, we've got a case called Zarda versus Altitude Express, which went against the gay person when it was a case before the three-judge panel, but that's gone up to the Second Circuit en banc, the entire bank of judges, and was argued in September of 2017, scheduled for an hour, and they actually took 2 hours for that argument. So things may be leaning in another direction. And in December, the U.S. Supreme Court denied certiorari in a case out of the 11th Circuit, so they're just not ready to pick this case up again. But what it looks like to me is there is a march in the circuits toward holding that sexual orientation discrimination can indeed violate Title VII. Thank you for watching.